Hi everyone, my name is Angel and I'm a law student. Today I'm going to continue the discussion from the last video. And without further ado, let's get started. So last time I've explained that in Indonesia, foreigners can't own any freehold property, but they are allowed to purchase any land or property under the right of use title. In the case of inheritance, the law is quite different for each case. And let's take an example. Mrs. Leni is an Indonesian citizen, and she's married to Mr. Leni, which is a foreigner. Based on Article 57 of the Indonesia's 1974 marriage law, it's called intermarriage. In this case, Mrs. Leni, the Indonesian citizen, can't own any property under the right of freehold title, the right to cultivate title, nor the right to build title, because then it would make Mr. Leni, the husband, the foreigner, also become the owner of the assets that Mrs. Leni have, and it wouldn't be possible because it's contrary to Indonesia's marriage law. Unless they have already made a prenuptial agreement which regulates the separation of assets, so when they got married, the property that they would buy wouldn't become a joint property, and Mrs. Leni can finally buy a house under a freehold title. But what if the case is like this? Mrs. Leni and her husband have never made a prenuptial agreement before, and then Mrs. Leni got an inheritance house under a freehold title. Based on Article 21, Section 3 of the Indonesia's 1960 Agrarian Law, Mrs. Leni must release that right within a year, or she could just transfer the right to a third party by selling it, or maybe she could just give it to her relatives. But the most important thing, Mrs. Leni must transfer that right within a year. Otherwise, the rights of that property will be erased, and the government could just come and take it and make it into state land without any appropriate compensation. And that's it. I hope you learned something today. Bye.